Hello, I'm Isaac Elliott, representing the defendants in this matter. My clients have expressed a willingness to work with plaintiffs to achieve a resolution to this issue, but they remain confident that no agreement to purchase Riot Foods was ever reached, and that a careful consideration of the facts will show this. UCC 2-2041 states that if there is good evidence existing suggesting that the parties intended to enter into a contract formation will usually be found. This evidence would include conduct by both parties, which recognizes the existence of such contract. In this case, the words and actions of the parties show that an agreement was reached to give the defendants the exclusive right to continue to consider purchasing Riot Foods. Though defendants were interested in purchasing the business and met several times prior to August 2016 to discuss the business and observe it in operation, they also knew that they had limited funds at their disposal and would not be able to purchase the business outright. Because of this, they reached an agreement with plaintiffs, with terms stating that plaintiffs would receive $15,000 while defendants would gain a trial run with the business that would require them to take on the daily responsibilities, costs, and profits from operating the business, giving them an opportunity to gain familiarity with the business while mulling over whether to buy it outright in the event that they received a loan from the bank. Lindsay Traeger testified that they entered into this agreement in part because the plaintiffs had another interested buyer, so the $15,000 payment was consideration for the plaintiffs holding the offer in place and not selling Riot Foods to another party until defendants had received more financial support, at which point they would decide whether to purchase the business outright or refrain from purchasing. Plaintiffs acted in a way that indicated that they had reached an agreement with these terms. They accepted the $15,000 payment from defendants, ceased negotiations with other interested buyers, and began to help defendants learn how to operate the business. Another indication that plaintiffs understood the agreement to state that defendants had not purchased the business outright but were paying for the opportunity to further consider the purchase was that Lindsay Traeger stated during negotiations that they were not in a financial position to sign any documents that would give them title to Riot Foods or any of the equipment necessary to operate it. Plaintiffs did not insist that the titles be transferred, but instead accepted the $15,000 payment and continued the process of fulfilling the other terms of the agreement. The fact that the titles to the truck, trailer, and all other equipment remained with plaintiffs indicates that no contract for the sale of Riot Foods was reached on August 20th, but merely an agreement to consider purchasing the agreement until a future date when defendants had enough resources to make a final decision. Though defendants ultimately decided to move in another direction once they received a loan from the bank, they did all that was required of them under the agreement reached, paying $15,000 and replacing equipment, paying employees, and generally acting as proper stewards for the Riot Foods business during their 2-month trial period, and therefore they have not breached their agreement with plaintiffs.